let's dive into our friend risk transfer. This is a CLE eligible course. This is NYPG10-25, right? 1 hour of credit. CLE credits will be provided. Make sure you either sign in, there should be a sign-in sheet, or do it electronically. And then we're going to go put this in our professional development trackers, right? For 1 hour. We got that? Okay, good. What do we do here? We defend employment. Let's connect that to risk transfer. Let's get into today's topic. Risk transfer and our opportunities under Section 29 in New York or Section 40 in New Jersey is like one of our most powerful tools, and it can help us unravel our most difficult cases. We have a powerful option in New York. So I'm going to talk today almost entirely about consents. Probably the number one question that people bring to me, probably the number one question we have. What can we do with a consent? When is a consent effective? What kind of cases can we wrap up with a consent? And what can we do with it? The most important thing is, guys, we could shut down our comp cases without waiting for a judge to intervene. As soon as we send off our consent, your workers' comp case might be over, depending on what you put in that consent. So this is a super powerful thing. And I'm going to show you today a case in which I used my consent power to blow up cases and demolish them in other jurisdictions, not even in New York. So buckle up, because this is a pretty exciting one. I'm going to walk you through an actual case today. We're going to call this case F versus OSIP. Claimant's name started with the letter F, and our client in this case was an OSIP employer. I'm going to try to walk you through some of the same things that you're going to see in your risk transfer cases. I'm going to demonstrate how we analyze these cases under Section 29 and Section 40 in New Jersey. We have to in this one. And then I'm going to show you how we used a consent in this case to take apart a pretty problematic, complex case that was referred to us because predecessor defense counsel, kind of screwed it up so bad that they sent it to us to fix it. The client sent it to us. So if you're wondering what case this is, it's a case that's in our system as 7035.0002. Go to that one if you ever want to look at a case with exemplars templates, look at what Greg Lois does in his cases. Yes, that's a New Jersey case number in our system. There was actually 2 New Jersey cases and a New York case, but all the consents and stuff were done in this 7035.0002 matter. And again, you can then see the name of the case and see how we handled it. So let's talk about this weird case, or this outlier case. There's a New York employment accident. Okay, that's usually how we get involved in these things. Employee works as a masonry laborer. He worked for a masonry contractor who was enrolled in an OSIP insurance program. So he's on someone else's project. The injury does occur on the OSIP job site, again, for an enrolled employee. He then gets an attorney and he files a labor law lawsuit, a civil action, against the general property owner, the project owner. The OSIP is liable as a defendant in that action, and they hired general defense counsel, and they were defending that case. He also brought, the claimant, a New York workers' compensation case. That's usually how we get involved in these things. He brought it against the masonry contractor, but the OSIP was ultimately liable in that case. He then brought a New Jersey workers' compensation case in New Jersey, essentially saying, I live in New Jersey, I was hired out of New Jersey, I got my medical treatment in New Jersey, and I feel like bringing a New Jersey workers' compensation case. So that's your third action. And then he also got treatment in New Jersey, and then the New Jersey medical treatment provider sued the OSIP as well, saying you owe me money, additional money in addition to what I've already been paid, okay? So if you're counting, we're up to at least 4 lawsuits currently pending in 2 states before 3 different judges. Now, predecessor counsel gets us into this situation, okay, and there's a mess. They then send the case to us, and now we enter into the case. And here's what it looks like to me if you were to diagram this case out. New York employment accident involving an OSIP employer. That spawns 2 New York lawsuits, the workers' compensation case and the civil action. And it also spawns, subsequently, 2 New Jersey lawsuits, a New Jersey workers' compensation case and a New Jersey medical provider action, right? So this thing is getting messy. It's going to get messier and even more complicated as we go forward. So the labor law claim, okay, that's the civil action. We have to know some things about the civil action. He brings it against the project owner. It's defended not by us, by different general counsel in Kings County Court in the Manhattan Civil Supreme Court. The civil action ultimately reaches settlement after arbitration for $3.95 million. And I'll just tell you as a brief aside, as you look through this case, if you ever go look it up in our system, the civil attorney kept telling me that they actually settled it for $3.8 million. They actually settled for 3.95. He misplaced $150,000, an error in his own favor. That's why we always say, get the closing settlement documents, get the closing statement, so you have a sense of what they actually settled their case for, because they will bald-faced lie to your face and then say, oops, whoopsie-doo, I made a mistake in my favor. Okay, so he ultimately settled it for $3.95 million. The second pending suit is a New York workers' compensation case. And a New York workers' comp case was accepted as compensable. They looked at it. They said, yes, it did happen on the OSIP job site. Okay, we're liable under the New York workers' compensation law. And during the lifetime of the claim, they expended over $600,000 in medical, temp, and lost time benefits, and ultimately an additional $175,000 in a Section 32. And again, this is not handled by LOIS. This is predecessor counsel goes and settles the New York workers' comp case for $175,000 Section 32. Would we do that if there's a pending third party? I'm hoping everybody looking around at you wonderful faces, you're not going, no, that's silly. Why would I close my case if there's still some exposure out there against my client? So they went ahead and they settled that case for $175,000, indemnity only. Again, you see it put in there, not handled by us. At the same time, they then go and file a New Jersey workers' compensation case. Now, you've got a great argument in the New Jersey case. What's the argument, guys? Lack of jurisdiction, right? That would be a perfect argument to raise in that case. It wasn't done. They argued essentially it was hired out of New Jersey, therefore New Jersey courts had jurisdiction. Sure, but it's a pending New York case. Benefits are already being paid. I think there was a good motion to dismiss that should have been filed in that case. Again, not handled by LOIS. Ultimately, they pay out another $218,000 plus in the New Jersey workers' compensation case, and that's without settling the case and without getting to permanency. So if you're doing the back of the envelope math, we're at over $800,000 paid out in this case so far. Again, all not handled by LOIS. The fourth lawsuit gets filed in New Jersey, and this is by the medical provider directly. This is something that you can't do in New York, but you can do in New Jersey. If you're a medical provider that provides medical care to an injured worker, you can provide that care, and then the statute allows you to just turn around and directly sue the employer for whatever you think that you should have gotten paid, right? So no, and that would never happen in New York. New York, we have the PAR requests, so the prior authorization requests, and then we have C-8.1s to resolve outstanding bills, but New Jersey doesn't have that, so a medical provider in this case files a direct lawsuit against the OSIP. Again, if you're doing the math, you're starting to realize, okay, we're in 2 different states, we're in 3 courts, and we're in multiple jurisdictions. So complication 1 is multiple jurisdictions in your third party and with your third party pending. Now, if you're wondering, how is that possible, Greg? How can someone get injured in New York, bring a New York workers' comp case and a New Jersey workers' comp case? Well, let me just tell you, it's absolutely allowed under both statutes, right? Both statutes say you can bring a workers' comp claim in this state and a workers' comp claim in any other state in which you'd be entitled to file a workers' comp claim, but the benefits offset, right? So you don't get the benefit of getting everything you recover in both states. One state should offset against the other, okay? I can also tell you in this case, it was very interesting, very rare, very strange, in that this person went and got all of their benefits and treatment and even settled their comp case in New York under Section 32, and then stepped into New Jersey, hired a new attorney, and filed the New Jersey workers' comp case and started over, essentially. Again, we didn't handle those 2 underlying workers' comp cases. But if we did, and I was defending that case in New Jersey, I would file a motion to dismiss for lack of jurisdiction immediately. And I hope everybody that just jumps out at you. It's a thing that you would do. But this brings it now, the factor that's our next complicating factor, which we'll talk about in a second, is how many plaintiffs' attorneys are we dealing with so far? Well, we're up to 4 at this point, okay? So that's complication 1. We're in multiple jurisdictions. We've paid different amounts in each one of these jurisdictions, either paid already, that $3.95 million, or the exposures. And again, this doesn't count your future exposures, because with those pending living workers' comp cases in New Jersey, those are not resolved. So those have future exposure attached to them as well. All right. Just trying to put the math up there for you. So your complication is, first, you're stepping into a lot of jurisdictions all at once. All right. Second complication that we step into, and this is where it gets even worse. We start off, when this case is referred to us, with 4 different plaintiff's attorneys representing the plaintiff, right? So they have a New York workers' comp attorney. They have a New York civil attorney representing them in their labor law or scaffold act claim against the OSIP or project owner. Okay, so that's 2. And then in New Jersey, there's 2 different attorneys, one representing them in the workers' comp case and one representing the medical provider in the action to just recover medical fees. So that's 4 different parties who are not cooperating with each other and do not know about each other. And the medical provider, the applicant's attorney, doesn't know about any of this. Okay, so you've got 4 attorneys working at cross purposes. Complication 2.5, so you were looking at all this, and again, the challenge is they don't know what they're doing. Any way we settle this case, some of these attorneys are going to be out, right? So if we settle the case or we do a global consent under the New York action, how do the Jersey attorneys get paid? From what? From where? How does that get resolved? And the complication got even more challenging because halfway through the representation in the New Jersey workers' comp case, the claimant fires his New Jersey workers' comp attorney and then hires a second one. So now we have 5 plaintiffs' attorneys that are representing this person in all of these different courts and all these actions. And those 2 attorneys in the New Jersey workers' compensation case were at odds with each other. They both put in fee applications trying to edge out the other one, saying, I should get all the fees from this case. The first attorney said, well, I filed the case and I pursued it and got him all these benefits. And the second one said, yeah, but I'm doing all the work and I'm going to get it across the finish line. So now we have 2 attorneys just in the New Jersey workers' comp case who are not getting along and are not going to be cooperative because they both think they're entitled to a bigger piece of the pie. Also, the challenge for us, of course, if we do settle the case under a global, how do they get paid? Generally, they would get nothing. So now they're going to be 2 attorneys fighting me over nothing. Okay, so that's where this case starts to get more complicated. Complication 3 is that you're in multiple states, different venues, sometimes within a single state, and I had 3 different judges to manage. In the New York workers' compensation case, you have a case before the board. Okay, you've also got the New York Supreme Court case, which was pending in Manhattan before a civil judge. And then in the New Jersey matters, you have 2 different claims, 2 different docket numbers, but they're consolidated before the same judge. All right. Now I'm just going to share this with you. Most New Jersey attorneys and even fewer New Jersey workers' comp judges know anything about New York Section 29 or risk transfer rules, reimbursements. They've never seen a consent. So unfortunately, in the Jersey action, we had to do a lot of education of the court because the judge had no idea what was going on. All right. And again, predecessor counsel never challenged jurisdiction, never fought jurisdiction, never filed a motion to dismiss, which put us behind the 8 ball. Okay. Again, before you blame me for all this tomfoolery that I'm displaying here, just recognize that this was all done by predecessor counsel before it gets referred to us, okay? And our job here was to unravel this and save the day for the client. So how do we best help a client like this who's got these problems? Multiple jurisdictions, 5 attorneys arrayed against them who are not cooperating. We all know that GL, or the General Liability Defense Counsel, is usually not steering the boat towards these globals. And now you've got a global that involves multiple jurisdictions. Our goal is always to reduce exposure to the client, our client. And we have to figure out what the best course of action is for that client. In this case, we have to navigate all these different jurisdictions, which have their own rules. And then we have got the competing interests of all the plaintiff's attorneys. The plaintiff in the civil action, the attorney is very happy. His fee agreement says I get 1/3 of $3.95 million. He's sitting pretty. The workers' comp attorney in the comp action in New York, they took $175,000 Section 32 and walked away, and they got an attorney's fee out of that. Again, we didn't negotiate that. We were never part of that. So they think they're out. They're like, I don't have a problem. This case is over. And then in New Jersey, we have 2 attorneys who have very different outlooks that are representing the same petitioner. And then we have an applicant's attorney. And the applicant's attorney is like, I don't even need to know about this third-party action. I just represent this poor doctor who's treating these people and expecting to get paid. We also have to manage or steer the litigation before these 3 judges. Because as I'm going to show you in the next few slides, when I talk about the chronology, what happens in these cases is the civil attorney, the plaintiff's attorney, files a nunc-pro-tunc motion, which means I get before a judge in Manhattan. And you know how judges in Manhattan feel about nunc-pro-tunc motions? Like, what is this? Why are you in front of me? Okay, Scott's kind of laughing because he's defended them a few times. And they don't want to know about this. Why can't you guys just resolve this? And you stand in front of them, you go, well, it's a little bit more complicated than he gets his fee and he gets his fee and let's close the case, right? This one's a little bit more complicated. On the other challenge is the New Jersey workers' compensation judges have to approve any settlement or dismissal. So they're like almost like a party to the case and they don't know anything about New York law. So there has to be some coordination there. All right. So what's our role? Our role becomes coordinating these competing interests. Our role becomes educating the judges, especially the judges in New Jersey, about what it means when someone accepts a settlement for $3.95 million in New York, and maybe I object to that settlement. What does that mean, or how does that impact the workers' compensation case? Before that judge in New Jersey, the attorneys representing the petitioner filed motions and requested oral argument on the issue that, well, it's a New York lien for a New York workers' comp case, and New Jersey has no interest. And they actually put, if you read in their brief that's in that file, they argued constitutional law arguments in there about why they shouldn't be encumbered by that lien. And our choice is, how do we maximize whatever reimbursement the client's entitled to? How would we close down their future exposure? And then how do I resolve that medical case, that medical claim that's pending against them in New Jersey as well? So we've got to try to wrap all these things up together and clarify and simplify this thing that got pretty out of control. Okay, sorry, I went too far. All right. So in order to win, to succeed for our client here, table stakes. We need to be able to calculate what is the best possible outcome. Okay, which means table stakes. We need to calculate out for our client. What reimbursement could you be due under Section 29 in New York? Which reimbursement could you be entitled to under New Jersey's law? And then you need to think about, okay, which one of them is more favorable to the client? Which way do I want to proceed? We've got to manage the judges in these cases. So when I stepped into this case, there was a pending nunc-pro-tunc motion, had to be opposed immediately and argued. But I also had New Jersey litigations that were going forward, and those cases were going towards permanency. So we have to manage the tempo of the two New Jersey actions to make sure the judges don't start reaching decisions in those cases before I resolve or retain my client's consent power, before I oppose the nunc-pro-tunc motion, before I negotiate a global settlement, and before I get all of these attorneys to either drop their cases, accept a dismissal, or settle out, right? We need to be persuasive. We need to go into court and argue before the judge in Manhattan as to why the nunc-pro-tunc should not be granted, why the judge should not cram down our rights. And we have to build some kind of consensus around all these parties who are not talking to each other. And I would tell you, I think that's one of the most challenging things. And sometimes one of the challenging parties we have to build some consensus with is our own client, right? That's our stakeholder who's going to say yay or nay to whatever plan of action that we come up with. All right, so that's the backdrop. So that's the challenge that's in front of us. Let's take a quick tour through the relevant statutes, and then we'll talk about how we unravel this mess for our client. So what is risk transfer? It just means someone else has to pay us back. We're always thinking in risk transfer about what kind of recovery does my client get? What kind of offset does my client get now? What kind of future credit do I get to reduce my future exposure? In most cases, it's going to feel like the civil action is settling before ours. Sometimes our case is going to settle before theirs because they're using our comp case to drive the meds in their civil action. We see risk transfer opportunities in cases with slip and falls, motor vehicle accidents, products liability, and then this case, right? A construction accident case taking place on a job site. There's strict liability for elevation-related injuries that's going to attach to the project owner or the general contractor, and that's what we're here to address in this situation. So what kind of cases can we get reimbursement from, and what's the amount of our lien? The term lien, I hate it. I hate it. I hate it because it's not a real good use of the word lien. Lien means you already have a money judgment. You just need to recover it. But in workers' compensation, when we talk about third-party actions or actions over Lien just means amount we've already paid and we're going to get back, all right? The law exists to prevent double recovery. That's easily what's happening in our case. We've got a recovery in a civil action, a recovery in a New York workers' comp action, and maybe a second workers' comp recovery in a New Jersey action, and then a medical bill that we're going to have to pay as well. So those are at least 4 recoveries to the claimant, and that all has to be coordinated. And so the goal of Section 29, it really isn't to return money to us. It's really to prevent double recovery and help us coordinate all of these potential sources of reimbursement to the claimant. Section 29 also allows us to subrogate. The third-party action is, in this case, going to be that scaffold injury. This was an elevation-related injury, and that's why they have brought this case. Again, the term of art here, every time I'm going to say lien going forward, it just means amount we already paid. I hate this word. I wish we could fix it. All right, how do we calculate our recovery? All right, this is relatively straightforward. This is not where we should get stuck. This is table stakes. When we have a third-party action, we should be thinking always, what's our maximum recoverable amount? What's our maximum recoverable lien? How do we do that? Well, under our New York law, there's a lot of ways we could calculate this depending on the facts of our case and whether the claimant, whether the future payments that we're going to have to make are fixed or speculative, and what is the medical position of the claimant. So one of the ways we'd calculate our recovery in the case where future benefits are not speculative is we just apply Section 29, a piece of case law called Kelly. We figure out what's the cost of litigation. We reduce our maximum recoverable lien. That's it. This is straightforward math. Everyone in this room should be just using our built-in calculators in our system to do this. If clients are listening to this and you ever need us to calculate this is something we've reduced basically to a math problem. Same thing with we have an example calculation I'll skip. Future rights, okay, those open cases. In this instance, there was an indemnity only Section 32 for $175,000. How do I feel about indemnity only Section 32s? I don't like them, right? Because that means medicals are open. That means as medicals are coming in under BISL, we would pay the medicals we'd pay the cost of litigation percentage of those medicals as they come in. In other words, our client would still have some future exposure. Again, we don't like that. That's why we try to close cases all at once. And then the last type of calculation we have to perform is where future benefits are speculative or unknown, and then we use a Burns calculation for that. So I'm not going to bother you or bore you by going through those. Again, all the calculations and all the money moving in this case are relatively easy to calculate using our calculators. You can also look into the matter and see the calculations I did. Well, I'll skip this because I already talked about it. I'm going to skip Terra Nova because we don't care. All right, let's go to the most important part of this, okay, which is the power of consent. In this case, we know that the arbitration came back at $3.95 million. We also know that the property owner was very happy to pay $3.59 million. So now that's our chief piece of leverage in this case. Claimant wants the money. We have the power to not give them that money. Okay, we can withhold our consent. And my goal in this instance was to withhold my consent to try to force all the parties to the table so that I can resolve all of the other 4 pending matters all at once, okay, and dispose of them cleanly and neatly. The power of consent is probably one of the most powerful things we have under our workers' compensation law in New York. The other parties must come to you. They cannot settle around you. They cannot accept that $3.95 million in this case, unless we say, okay, I bless this. I grant you my permission to accept it. Now, do we need a reason to withhold our consent? Do we need a good, valid business reason to withhold consent? No, you can withhold consent for any reason. I don't see a consensus on that one. So you can withhold your consent, right? And you can play around with consent. This is like wild west, okay? There are so many options we have in terms of granting our consent. We say, no, you can't accept that $3.95 million unless you, and then you can come up with almost anything. For those of you who took property law in law school first year, remember that property law case that said that the tenant had to bring a rose every fortnight to the landholder. Remember that case? Like you could come up with ridiculous things to have your consent granted, right? You could say, hey, you've got to come over to my house and mow my lawn once a month, and then I'll give you my consent. This is wide open. Okay, there's nothing that says that when someone asks us for a consent, that we only have to negotiate money with them. We can negotiate any part of the case that we want to negotiate with them. We can negotiate future rights. We could say, okay, I'm going to give you my consent. You can accept that $3.95 million. But here's how this is going to impact your future workers' compensation benefits. Okay. Now, what's cool about this is I can negotiate away somebody's future workers' compensation benefits. And after I say I grant my consent and I send my email to them with my letter attached, that's the end of their future benefits. They do not get to go before a workers' compensation judge. We do not have to wait for a workers' compensation judge. You can do that immediately. Okay. That's our practice here. Okay. You can also agree, hey, if I have a future offset, so I have a future exposure, I'm going to have to pay you workers' compensation in the future. I can agree with you privately in this consent how that offset's going to be applied. Now, I like a dollar for dollar offset. That's what I did in this case. Okay, I did a dollar for dollar offset. I essentially said, I'm not going to pay you any more future workers' comp benefits until the remaining benefit that has not been reimbursed to me that you've obtained is exhausted. Okay, and I'm going to show you that in math in a little bit, how that works out. Okay, so that's a pretty powerful thing. You could say, hey, you're going to get $2 million out of this, and I'm going to walk away, and you can't come back to me unless you spend that $2 million first. Okay, that's what that future offset credit is. You can also agree when the credit begins. In other words, when we stop paying. What do we put in our consents, in our form consents? It always is, we're going to stop paying as soon as I email you this consent, as soon as I send this thing to you, right? We try to take advantage of it in our form of both of those ideas. My credit's dollar for dollar. It takes effect now. I'm not waiting to go to court. We're done. Your workers' comp case has come to a conclusion. Go with God. I hope your journey is fruitful, right? We're done with that. This is powerful. There's nothing else that I've ever seen. There's certainly nothing like this in New Jersey workers' compensation law that A, either allows us to consent or not consent, or B, set the terms of our consent like this. I'm not aware of any other jurisdiction that allows something as wide-ranging as this. So you're in the driver's seat at this moment. So the second the claimant gets that $3.95 million judgment and turns around to you and says, okay, let's go, you're now in control of that case. All of the plaintiffs in those actions, the petitioner's attorney in the Jersey Act, you're running the show. Okay, you've got the power. All right. And okay, it keeps jumping. All right. What's the first thing we ask for? Hey, what's your proposed settlement agreement? Or what's your proposed closing statement, right? That's the first thing I'm going to ask for. In this case, my adversary lied to me. If you go into that file number 7035.0002, you'll see my first consent was for $3.8 million because that's what they told me in writing. And there's email saying this is what our consent's for. Then I finally get the proposed closing statement and I find out the real number. And then I went back and I changed my consent. Okay. First step, let's get that proposed closing statement, get it in writing what that third party action is proposed to settle for or going to be resolved at. All right. Next, we know we're going to drive this case towards a consent. Let's use our consents. Okay, there's 4 of them inside of our system. The templates always begin with the same things, a recitation of contingencies. Okay, that just says essentially that A, you're going to give me a finalized closing statement. B, if you make any changes to your settlement, this whole thing is null and void. And C, you understand that if there's a problem with this consent or this settlement, that we're going to resolve it before the workers' comp board. Now, these are incredibly important, right? We should never change these 3 contingencies. There's never a reason. In fact, if opposing counsel comes back to you and says, well, I don't like your consent, you got to change the law. Nope, forget it. No consent. Okay, give me everything. I'll take it all. Okay, because that's what happens if they settle a case without our consent. We get everything. There's no holdbacks. You know, they don't get to keep the cost of litigation. So the first thing is super important, that finalized closing statement. That's required by court rules. If they tell you they don't have one, they're lying. You should get it from them. Second one, any modification or adjustments, that's usually to the number, is going to make our consent invalid. And the last thing is that we're going to enforce it before the comp board. Why? I'm good at before the comp board. I do not like going into Supreme Court and trying to convince a judge who's not interested in what's happening in a workers' comp case to enforce my agreement. Okay, so I prefer to have this resolved before the comp board. That's where we are excel. So these contingencies should never, ever change. Okay. The other things we put into our case is we always say this is effective immediately as soon as I send you the consent. As soon as you consent to that civil action, and for whatever terms you've negotiated, again, this is the Wild West. There's so much latitude that you have. There's such a far-ranging power you have. Whatever you've arranged for as the consideration for you granting your consent, it's effective as soon as you send the consent. You don't wait for it to be signed and returned to you. You don't wait for someone to send you an email back like, thank you for the consent. Okay, we're a good deal. It's done as soon as you send it, which means you might be telling your client immediately, hey, by the way, you don't have to make any more payments. You're done paying. Simplified consents are the best consents. I know in the past we had these long 10-page long consents that cited every potential case law that was in the world. Our new ones are very streamlined. Please use them. Do not get creative here. If you're saying to yourself, oh, I need to change the language of this to adjust in some way, come see me or Tashia, okay? And we're going to probably sit you down and say, nope, don't negotiate to that, or don't change this language. Keep it as straightforward as you can. In fact, if anybody wants extra credit, figure out ways we could take words out of our consents to make them even shorter. I think that would be really amazing. Okay, so if you're that kind of person and you're like a human Grammarly, please try it. I would love to get them even more tight. All right, next slide. Okay, now you've now issued your consent to opposing counsel in the civil action. It's going to have an impact on your workers' comp case. Let's tell our client what we did the same day we send the consent to them, because that's the same day that maybe our client's going to start taking a holiday, meaning not paying. That's the same day our client's entitled to get money back, right? The clock starts running on opposing counsel to send us a check that day. Once you send that consent and you've told your client, stop paying, stop issuing more benefits, please mark your system, don't authorize any more treatment, everything's come to a conclusion here. And then the opposing counsel comes back and he's like, oh, I'd like to change some of the terms of the consent, or there's some other words. Okay, that doesn't mean that your first consent is now somehow undone just because they emailed you back. The consent is in effect as soon as you send it. Don't care what they respond with. So your instructions to your client at that point are whatever you've put in the terms of your consent, okay? Now we do want to get a signed one, because the statute says a final consent is final when it's signed and notarized and returned to you. But those words have almost no meaning under Williams, which says as soon as you can agree that as soon as you send the consent, it's full and binding and effective, okay? So there will be an automatic task created in our system to have your paraprofessional follow up for a signed consent. All right. So what's a valid consent? It's one that was entered into openly, authentically, transparently, ethically, honestly. It's not revoked, which means that any of the facts in our contingencies were not violated. It means we sent it to the correct party, right? Check your email, make sure you send it to the right person. Once we send it, our obligation to issue payments under the workers' compensation case are over, or could be over. That's the moment when our client should be advised of that, okay? Is everyone crystal clear on that point, okay? There's no more negotiations after that point. And if there are, by the way, again, you're still in the power seat. You're still in the seat of, oh, you want to change something, or you forgot to tell me about something, or oh, you needed to get a Medicare set aside in the third party action, you didn't do it, or whatever it could be. That doesn't matter, right? Our consent under Williams, as soon as we send it out, is good. Now, a consent is finalized once the plaintiff signs it, notarizes it, returns it to us. And that generally means, what finalized generally means is, that's when their attorney is going to release the funds from escrow and pay them. So generally, when I issue consents, I usually get them back pretty fast because that's when the attorney can pay themselves, right? The plaintiff's attorney in the third party action, and can play the plaintiff. So usually they should be very cooperative about this. This is the moment where all of a sudden your opposing counsel is so hard to get on the phone or get back to you is getting back to you snappy, because this is their end of the month bonus that's on the line for them. All right, what do we do with a consent? Where do I file this thing? Nowhere. Nowhere. You just closed or resolved or changed the circumstances of your workers' compensation case, and you have no obligation to file this anywhere or bring it to the judge's attention or do anything with it. And you can, but you don't have to, all right? They all state that the consent is effective on the day we send it to the plaintiff's counsel. Again, this means we stop paying benefits. Our case is essentially stayed as soon as we send it. And we could stop paying even in the case where you're under judicial direction to be paying a carrier continued payment immediately. Now, sometimes you won't be able to suspend completely, but you'll maybe be able to reduce because you're going to get an offset. All right. So that's another thing that could happen. You don't have to wait for a judge's order. You don't have to go for a hearing. You immediately make the stopping of payment or the reduction, whichever you've negotiated. All right. Let's put all of this together and apply it to our case, F versus OSIP. Again, this is our complicated mess of a case. It starts with an accident at a work site in New York, spawns 2 New York lawsuits, a New York comp claim and a New York civil action, spawns eventually 2 New Jersey lawsuits, a New Jersey comp claim and a New Jersey medical provider case. Again, this is exactly what Section 29 was intended to resolve. This is exactly what your consent power is meant to clarify. This is when you see fact patterns like this and you're starting to go, and we've got, in this case, we have prior defense counsel's fingerprints all over it, making the thing worse than it needed to be. You shouldn't be saying, oh, this is so complicated or this is so tough. You should be saying, oh, cool. This is a chance for us to flex our Section 29 muscles, right? These are the ones that are actually you get to play around with. You've got a lot of latitude on these matters. All right, so that's the facts. First thing we have to do in this case is address all the complications that we talked about. Lots of parties, lots of attorneys, a couple of judges, different courts, different matters pending at different speeds. That's another challenge. The first thing is figure out how much reimbursement is due and basically analyze both cases under Section 29 or Section 40, figure out which is most favorable to you. Under this circumstance, Section 29 and Section 40 were essentially equal in terms of reimbursements. Compare the 2 state statutory schemes, determine which is most favorable. Next, figure out if we can leverage our litigation position to resolve all the pending claims separately or together. So when I looked at this, I said, wait, is it smarter for me to try to resolve off the New York cases separately or and just close them out, right? Because I still had ongoing medical exposure in the New York case and I had an easy Section 29 obvious reimbursement. Or should I also try to lump in the 2 Jersey cases, again, brought by 2 different attorneys and before a judge who doesn't know what really New York workers' comp law is, and try to mush this all together into one big global settlement? I also had to try to think about what are the future exposures you have in this case. The future exposures in this fact pattern were the New York workers' comp case still had open medical. So there is some limited exposure available there. But the New Jersey workers' comp case had permanency exposure as well as future medical. And the medical provider action also had a $27,000 medical bill, which is hanging out there. So, the determination was, hey, can we get all of these things closed up at the same time? The next step is, okay, what's my action plan to try to get this plan of action, which is really to use a global consent on the New York side to close down all the exposure in New York, resolve how much money my clients can get back, and then also resolve the extra jurisdictional cases. I should also point out that there is specific case law in New York that says a consent in a New York workers' comp case, and actually, by the way, a Section 32 settlement can resolve claims in other jurisdictions. Not necessarily enforceable in other jurisdiction, but you can certainly resolve, for example, a New Jersey workers' compensation case by way of a Section 32 in New York. You just got to get the New Jersey workers' comp judge to actually recognize the other state, okay? So it is possible under the rules. So we got to address these complications. So here's what we did. So the first thing is we got to get all the parties and all the players together. And we cannot rely on general counsel to do this. If you've handled OSIP cases, which many of you in this room have done, you know general counsel is not always driving the boat. They're always often coming to us. Hey, what's happening in the comp case? How much has been spent? What's going on? So they're not always the captain of the ship. In this instance, I want to take control of all of these cases. In fact, that's why the client sent it to us to say, hey, can you fix this? It's all the toothpaste got out of the toothpaste tubes. Can you guys put it back in there? That was our challenge. So the first thing is, can we take control of these cases, all the jurisdictions? So we make our appearances. If you look in these files, you'll see in New Jersey, we do subs of attorneys. In New York, we do notice of appearances, so that we're out there and we're going to try to collect everybody together. Next, present the plan to the client. Hi, client. Here's your maximum possible reimbursement under Section 29. Here it is under Section 40. Here's what you can do. Here's what we think we can obtain. Here's what we recommend you do. Do you agree? Okay. I start with the end in sight, which is, hey, we're going to steer towards a consent. So I'm saying to myself, I've got to get everybody to understand that this money is going to get tied up. I'm going to hold it up until I can get all of these stray dogs who are not talking to each other and in fact at odds with each other onto the same page. So informing them and telling the Jersey attorneys who are like, I don't care what happens in New York. I say, you better care, because I'm going to try to settle around you. I'm going to try to resolve your case without your participation. All right. Change slide. Okay, go back. All right, the other goals we have, so you got to calculate the maximum reimbursement to just so we know how much is at stake. Okay. Again, I think this is table stakes. I'm expecting people to know how to use the calculators and to deploy them effectively. The next thing that I had to do, because when we came into this case, there already was the nunc-pro-tunc motion pending in New York Civil Supreme. I had to put on my lawyer costume and put on my suit and go into New York Civil Supreme and argue before the judge and say, first, Judge, there's a lot. This is not a simple nunc-pro-tunc motion. This isn't just us being obstinate. Your Honor, you have to understand that there's other things at stake here. And in fact, there's extraterritorial cases pending in New Jersey that are going to be dependent on this pile of money, this $3.95 million being preserved. And Your Honor, if you grant the nunc-pro-tunc motion and do what they want to do, which is cram us down here in New York, have us just be reimbursed for what we paid in the New York comp case, you might be leaving the same exact party, the same employer defendant in the New Jersey workers' comp action and medical provider action without an avenue for reimbursement. Because Your Honor, what if the claimant gets the $3.95 million and then goes and spends it all on a wonderful Viking sailing yacht and just sails off into the sunset, right? We're never going to see them. Okay, so that's the argument we have to make. I can tell you, we don't want to be defending nunc-pro-tunc motions because the judges are not involved in them. This judge kept coming out onto the bench, he kept calling the case, and he'd let us argue, and then he would close the record, and then he'd say, counsel, can you go talk about this in the hallway and come back and figure it out and come back? And I would go outside and I would argue until I was blue in the face with opposing counsel, because he kept saying, I don't care what happens in New Jersey. I'm like, it's your client. He just happens to be in another jurisdiction, you silly heart. And you're going to get him in trouble because he's going to take this comp recovery in New Jersey. And then I'm going to come and attach his assets, you silly heart. And I had to keep trying to explain that to him. And he kept coming back. And ultimately, eventually, the judge said, look, I think this is complicated. I'm not going to grant this motion. You guys can go brief it. Okay, plaintiff's attorney doesn't want to write a brief. All right. And the other thing we had to do, so we had to make sure that was stayed or not moving forward, because we needed that leverage in the Jersey cases. Okay. And then what we had to do in the Jersey cases was file motions to dismiss in both of them for lack of jurisdiction and also arguing this is duplicative. Your Honor, they went and got a New York workers' compensation claim. They actually got a Section 32 recovery, which I argued was analog to a Section 20. And then, Judge, they came before you and started the whole thing over again. And the judge kept saying to me, but Greg, you guys let him do that. And I said, Judge, it wasn't me. It was different counsel, right? But that's not the most compelling argument. Ultimately, the judge made us brief it, and we had to oral argue that about how the choice of law, in other words, the state in which you receive benefits, controls your right of recovery. And there's case law on that. So we were able to prevail by pointing that out to the judge. We also had two other goals to accomplish. Remember, silly-hearted predecessor defense counsel in the New York workers' compensation case paid this person $175,000 Section 32, which was silent on as to whether our Section 29 lien rights were established to that $175,000. So we had to make an argument, and we were ultimately successful in saying that that was all lienable money. Okay, that's just making an argument, all right? Because we wanted to get reimbursed for that amount. We also had to try to convince the workers' comp judge in New Jersey that any global consent that I made in the New York action, I had to point out the case law, could be controlling on the same party's interest in another state, okay? I can just tell you she did not like that argument, because you're essentially telling one workers' comp judge that she has to do what another workers' comp judge in a different state tells her to do, right? And that did not fly. In fact, she was not convinced by that at all. Ultimately, so our plan here was to withhold consent and maintain the withhold of consent by defending that nunc-pro-tunc motion so that we could try to resolve and claw back as much of these other monies and avoid as much of the future exposure that we had in the other cases as we could. Our plan and the offer was essentially, I will grant you my consent, and New York, you will give me my maximum reimbursement now. New Jersey, you will give me my maximum reimbursement right now. New Jersey medical provider case will be dismissed. We're gonna have the judge agree that that case should be dismissed with prejudice. And we're also going to eliminate all of our future workers' compensation exposure. Right? That was the goal and the plan. And the real challenge, honestly, was just getting all the parties together. So what do we obtain? We did a global consent, and you can read it in the case. It says we're going to get an immediate reimbursement of $554,000. In the consent, I asked the other party to recognize, I said, it's as a condition of this consent, you recognize that the $175,000 that predecessor counsel silly-heartedly paid to you under Section 32 indemnity only, that is going to be considered a lienable amount of money. All right. Now, our practice here at Lois always, when we do a Section 32, right, paragraph 10 always says, this is pursuant to Section 29, we reserve the right to argue that this money can be lienable and recoverable, right? Something along those lines. That's why we do it, just in case downstream. And by the way, they did that settlement in 2018, and this global settlement was reached in 2024, right? So that's to protect us downstream. 6 years later, the silly-hearted claimant in your workers' comp case now gets $3.95 million. You don't want your client to be out any of that money that they've paid in a Section 32, right? So these are important things to do. That's why we have these templates. That's why we use these best practice language, and we don't delete it, okay? Because it could protect us from something we don't even know could be coming down the line. The consent also says we have no future exposure in any case until the remaining credit of just a little over $2 million is fully exhausted, okay? That's your Williams argument for dollar offset. Now, is this person ever going to come back and do we have any real future exposure? Absolutely not, because I'm pretty sure they're not going to go and get $2 million worth of Band-Aids and back rubs in the next 20 years. It's just never going to happen. So this is essentially a closure, okay? It full and final closes the New York workers' compensation case because in the consent, I said we have no future liability under BISL or anything else to pay for any future medicals. And then I used it to coordinate the closure by judicial order of both of the New Jersey claims. And if you look in that file, you can see the closure orders from the judge. Okay. And parts of this, you don't feel like you're being an attorney, by the way, or a paraprofessional, right? Parts of this, I feel like I'm leading all the parties. I'm trying to get these people that are at odds with each other, the two New Jersey attorneys representing the petitioner in the New Jersey workers' comp action, were not speaking to each other and refused to appear until the judge called them both at the same time because they were disputing who got what percentage of the fee. And I kept saying, hey, silly hearts, your fee might be 0 of 0. Like, show up, okay? We've got to get everyone together. We had to do a lot of explaining to them, right? And have the authority to tell them, like, no, this is how this is going to work, and this is how you're going to get paid. We had to persuade the New Jersey comp judge. Actually, the New Jersey comp judge was much more challenging to persuade than the New York Supreme Court judge here in the non-protunct motion, because she really just had never seen this before and never seen a case with this fact pattern before, and really wasn't certain if Section 40 allowed for what we were trying to do. We also recognized that the biggest challenge in this case was that New Jersey attorneys would get absolutely nothing under the consent that we had negotiated. And that's why they were fighting. And that's why they were refusing to abandon their position and were arguing and making constitutional law arguments. And we're saying, I'm going to take this up to the appellate division. So I said, okay, we got to get creative here. Let's do something that's really wild. And so what we did in the Jersey comp case was we paid the claimant on paper a $100,000 Section 20 lump sum dismissal. That's fresh money. Okay. So the Section 20 is just like Section 32 in New York, same concept. So on paper in New Jersey, we did a $100,000 Section 20. But we said the Section 20 is subject to reimbursement under New York Section 29. Okay, that's already a little bit wild because I'm giving you a New Jersey settlement saying it's subject to a New York law reimbursement right, which meant effectively the claimant got nothing. He got $0 from the $100,000, and we didn't actually even pay it. But it enabled us to pay a counsel fee of $20,000 that the two attorneys in the New Jersey workers' comp case could split between themselves. And they did like a 60-40 split between them. So one got $16,000 or $12,000 and one got $8,000. And that's how we were able to close that case. Again, no money moving to the petitioner in the New Jersey workers' comp case, right? We also put into the consent, I put a statement in there that the medical provider case was going to be summarily dismissed, which it ultimately was. Okay, so that's not lawyering, by the way, really, right? That's getting everybody to the same table, facilitating like some normal conversations. The two dudes who just couldn't be normal, pulling them aside and crafting up another side agreement for $100,000 that was a sham agreement that would just pay them an attorney's fee so they would stop gumming up the works and screwing up the settlement for everybody else, right? So again, that's not really lawyering. That's just like putting on your thinking cap and trying to figure these things out. And that's what I think these kinds of cases take. Like I think third-party risk transfer cases, these are the times when we have to apply all these concepts to these wild situations. All right, so where we started, I took over this case, the client was out $5.05 million. That's out the door money, already out. With negotiating these global consents, managing the tempo of the litigation in the two different courts, and then figuring out a creative solution to get rid of the Jersey comp cases, our client ends up getting $554,000 back, and their total exposure ends up being no future exposure and $3 million out the door. So that's a $2 million savings in a couple months worth of lawyering, right? And that's a pretty big deal. I mean, I wish I was taking these cases on contingency, right? 20% of $2 million would have been pretty nice chunk of change. But that's the impact you can have, right? And so I would also say when you see like these wild or bizarre fact patterns, you know, multiple courts, different types of cases pending, you're in front of 3 different judges, you've got 5 plaintiffs' attorneys that ultimately arrayed against you, you've got defense counsel in the civil action who I know is not cooperative, and you've got a risk professional who's kind of like pulling their hair out, right? And then of course the added stress of, you know, this is 3 cases inside a practice master, so you're trying to keep all of that organized. I think this is a lot to manage, okay? But some takeaways. You have a powerful tool here, okay? Just withholding consent is a $2 million back in our client's pocket. Like that's a big deal. That's people hired, that's pencils and paper and equipment and whatever else that employer needs to get their job done. Your written consent in this case is really what was the powerful tool. Knowing how much money could fly back and forth, diagramming out the case. You know, if you go into the file, my notes, I don't know if they're in there or not, but I diagrammed out the case just like I did on this thing. And so when you have these cases with multiple parties and multiple cases in different areas, it's useful sometimes to diagram it out and start to think like, who's paying who and where's this money go? Once you're issuing the consent, right, this powerful tool that you have, your case is effectively over. You should be instructing your client that moment. Negotiations should be concluded when that consent is issued, right? There are things that can emerge afterwards. The most common one is going to be, oh, I told you it was for $3.8 million. Whoopsie-doo, I made a mistake. Actually, we're getting $3.95 million. That's a common run. That's a good valid reason, I think, to redo a consent. But not because, hey, we forgot about this or we didn't know about that suit or these other things. Like, we should be on top of these things. And the last thing is, when you're in a third party or risk transfer place, I know we can get bogged down on like how much money is moving, who owes what to what. But once you have that figured out and maybe diagram it out, maybe that's a useful way to do it. The next step is like, okay, how do I get all these people to collaborate together? Like, how do I force them into a phone call where everybody's going to listen to this? How do I force this in front of the right judge? Or what do I do? And how do I explain why I'm withholding my consent? Because when you're withholding the consent, you better have your plan already in your head as to what you're going to try to drive this, right? Before you do it. Those are some thoughts. All right. That's my presentation for today. I hope you found it useful and maybe a little bit exciting and inspiring. Let's go out there and tackle those ugly cases. We have 5 minutes for questions, concerns, comments, compliments, contentions, criticisms, any other Q or C word. Yes, Miss Powell.
Oh, just one thing in our consent agreement, we always get pushback. I think it's number 3 that says that the net to the claimant, right? If it's not this amount, this agreement is void.
Yeah.
So I don't know. I think ever since we started using the new consent agreement, we've gotten pushback. So one of the things that we've done or I've done is saying like the claimant is not to get no more than that amount.
Yeah, that's fine.
You can get less,
right,
but no more.
That's fine. Okay. That's fine, right? We're trying to figure out exactly how much we're entitled to be reimbursed, right? And we're trying to just constrain that down as much as possible. So that, I think that's effectively going to give us the same thing. At least we know what we're waiving. What are we giving up and how much are they going to get? I think that's important. Yeah, I think that's fine. All right, you're nodding. Good. I'm glad we agree. When you and I agree, I know everything's good. All right, any other questions, comments? Okay, thank you, everyone. Don't forget to fill out your professional development tracker. Okay, this was NYPGT10-25. And don't forget to rate me and tip your waiters. Thank you.